Hi, everybody. I hope you're watching this. As promised, I wanted to cover Chapter 11 because we had the special guest speakers and all the campuses from DNR. So I hope you enjoyed the presentation from DNR, and I hope it excites you to get into perhaps that specific facet of law enforcement. Of course, it interests me, so I'm hoping that it follows suit for many of you. All right, anyways, Chapter 11, Theft and Analogous Offenses. Let's move on. All right, so various theft offenses. Depending on the circumstances, a variety of crimes criminalize stealing. Of course, we know stealing is wrong. It's taking from another, someone else's property. So we're going to briefly cover larceny, receiving stolen property, extortion or blackmail, embezzlement, false pretenses, forgery and uttering, identity theft, theft of intellectual property. Okay, so the elements of larceny. If we look to the purple, I left these in color as I normally do for a reason. The mens rea, the mental part of it, the intent to permanently deprive an owner of a possession. The actus reus, the actual act, taking and carrying away, thus the property of another. It seems simple. I know we've covered this many times over, but it is so relevant in your career. That's why we keep on discussing it. It applies to everything. So, regarding larceny, the taking element of larceny refers to removing the property from the possession of another person, taking it away. The carrying away, which we call asportation, which is the removal, the no longer being theirs element of larceny to occur. There is no requirement that the movement be significant. Again, it doesn't have to be any distance. It can be, I'm taking it from one classroom to another and I'm going to hide it in my desk and you're not going to find it. It's larceny. Of course, the mens rea of larceny, intent to permanently deprive the owner of the property, is the same as an intent to steal. Just because finders keeper, losers weepers. If the owner of the lost property retains constructive possession of the property and the finder keeps it, larceny occurs. So you find something, lost property. Say you're shopping, let's say downtown Blue Ridge, where everybody shops, and you're sitting on a bench resting, and you look down, and underneath the bench is a gold bracelet. And you notice, my goodness, someone must have lost this. And you keep it, and don't do the proper thing. The intent of the finder is paramount. Thus, if you're intending to keep it, even if there's no identifying information or attempt to get it back, the finder, in most cases, again, dependent upon where it is you work, will be guilty of larceny if he sets out at the instant it is found to keep it permanently. So you reach down, you grab the gold bracelet, you kind of look around, looking at it, no one's looking, you stuff it in your purse or you put it in your pocket. It's larceny. So, receiving stolen property. Let's do a what if. What if that bracelet that you have, you didn't think it had any identifying marks, but there it is underneath the bench, and it ends up being a stolen item, and for some unknown reason you get stopped by law enforcement and you have this bracelet on, and he or she, being the officer, notices the bracelet because it's obviously very expensive, as was stolen in a burglary, and there you are wearing it. You received it. It's a crime for a person to receive stolen property, even if that person did not actually steal it. There you are. Excuse me, you found that bracelet, and that's just one example. You received it. Most states do not require proof of actual knowledge that the property was stolen. So in some instances, I don't know, officer, I'm sorry, I didn't know, I had no idea, I found it on the ground. Now, in the most reasonable officer is going to say, well, you should have turned that in, and perhaps if you have a clean record, deal with it accordingly. But there is that chance that you could be charged with receiving stolen property and larceny just because you didn't turn in. Knowledge, often inferred. You know that's not yours. You know that you found it and it belongs to someone else. You should have turned it into law enforcement. Some states do require specific proof that the defendant actually knew the property was stolen. A lot of them don't. Again, it depends. All right, so we're going to keep moving on. Extortion. Extortion, also called blackmail, consists of taking another person's property by threats of future harm. Whoops. We jumped ahead for some reason. I apologize. Give me 1 second. I pressed the wrong button. We're live. Okay. The difference between extortion and robbery is that extortion involves a threat of future harm. So if you don't do this, then this is going to happen. Okay? So I'm going to keep this unless you do this for me. I'm going to keep your mom's diamond ring, but I want you to go ahead and steal that TV for me, but you need to do that, otherwise I'm going to keep it. Or I'll destroy your mom's ring. I'll smash it, I'll throw it in the river or whatever. White-collar crimes. Various crimes committed by corporate executives or other employees in the course of their employment. I always hated this term, white-collar, blue-collar, but because it's mentioned all the time, white-collar, blue-collar, we have to cover it. I mean, it basically applies to those who are affluent, those who have money, those in high executive level, if you will. Called white-collar because the defendant is typically a businessman, as opposed to a blue-collar worker who works perhaps in a steel mill, in a lumber yard, or just an average Joe like you and me. Of course, an example of white-collar crime could be embezzlement. So, let's talk about that a little bit further. Elements of embezzlement. Mens rea. Yep, same words. Over and over and over and over again. The intent to fraudulently retain and permanently deprive a possession. The actus reus part. Conversion of property to own, use, or possession. Of course, the defendant is in lawful possession or control of property. So it occurs with the intent to steal or defraud a person in unlawful possession of the property, deprives an owner of his or her property for a permanent or indefinite period of time. It's converted to theirs, thus the conversion. But it's different, a little bit. It's different than larceny because the property comes lawfully into possession of the taker and conversion is required. Ownership. Converts. I've taken. Now it's mine. Could be money. Most of the time it is. They've embezzled money. They embezzled stocks. There's a monetary equivalent, and now I'm putting it from your riches into mine. I've now embezzled your investments, and I've stolen from you, and I've defrauded you, and I've taken all this and had it be mine. All right. If we would have had class today, here is a levity slide. I saw this one. I thought it was funny. I actually shared it with some of the English teachers at North Georgia Tech. They got a kick out of it. I didn't do nothing. Who can solve this? This is kind of a hard one. Can you get it? I can't tell if you're shouting it out, so I'm just going to move forward. Up to a point. All right. Let's discuss false pretenses. False pretenses is shorthand for obtaining property, by deception. the victim voluntarily turns over the property to the criminal due to some sort of fraud or scam. But they had no idea what was going on. For example, investing your life savings in a non-existent diamond mine. How many of us have gotten calls from Kenya saying you're a lost relative, or invest in this, or we found this? You know, it's all embezzlement, false pretenses. It is distinct from larceny because of the deception or false representation involved. You get all these garbage emails, you get all these garbage phone calls, and everybody's trying to scam you. All right, forgery. Mens rea, yes, again, intent to defraud. The actus reus, false signature or material alteration, thus the forgery. It's changed. So the writing would have been legal significance if genuine, and then above the intent to defraud, signed or alter without authority. Forged signature. That's a simple explanation right there. An example. So when we add the uttering facet. So forgery is the false making or material altering of a document with intent to defraud. So you take and steal someone's check, you forge their name, or email spoofing is an electronic form of forgery. Whereas the uttering refers to passing a forged document to someone else. So you break into someone's home, you steal a checkbook, you sign their name, make it out to cash, go to the bank, either go through a drive-through or you run it through Home Depot. Sometimes you can just run a check in, and someone who's lazy at the register will run your check. You can make it out to whatever you're buying. They don't ask for ID, and now you buy a chainsaw. So you uttered it. You've uttered a forged instrument. Identity theft. Identity theft occurs when someone uses or attempts to use sensitive personal information of another person with intent to defraud. It's both federal and state. It affects approximately 8 million households in the United States a year. You see often the threats of identity theft. There's commercials daily about this issue. It has become a plague. Often very difficult to investigate and prosecute. Eventually you catch them, but the damage, unfortunately, to these poor victims is already done. Some people will do anything. So I did some research, of course, and I found some interesting stories. Although, to some extent, some are funny, some not so much. So, I'm going to share this with you. It's working.
Does an American citizen have a constitutional right to own a gun?
Skip ad.
10 cases of identity theft that will make your skin crawl.
Oops.
Number 10, dead mother.
Sorry, buddy. Hang on.
It's a tragic fact of life that you'll probably live through your parents' death. But if there's one way to shred any sympathy people have, it's using your deceased mother's identity to defraud the government. For Thomas Prusik Parkin, that was apparently the next logical step. In a plot somewhere between Psycho and America's Dumbest Criminals, Prusik Parkin actually dressed up as his 73-year-old mother Irene, wig and everything, to continue claiming Social Security. And that's not to mention the $2.2 million New York townhouse that she left behind. Prusik Parkin carried on the charade from 2003 to 2009, but he was eventually rumbled when his mum's house went into foreclosure and he claimed that new buyers would be living in his home illegally. To get it back, he arranged a meeting with the already suspicious district attorney at the house, where they found him wearing a red cardigan, lipstick, had manicured nails, and breathing through an oxygen tank. It's not hard to see how he got 12 years in prison after that move. Number 9. College Scammer. Esther Reed is quite the character. Like most serial scammers, she had a major rap sheet, but she was known for stealing identities so she could go to university. At least you could admire her desire for education, unless you just really liked the college lifestyle. Regardless, in 2004, Reed found the identity of Brooke Henson online, a 22-year-old South Carolina woman who went missing in 1999. Despite the fact that Henson was a high school dropout, Reed used the name to get admitted to both Harvard and Columbia universities. But when Reed applied for a part-time job under Henson's name, the interviewer looked her up and found her namesake was missing. So he did what anyone would do and called the police. They concluded that Reed was in fact Henson, but she just didn't want to see her family. One savvy detective, however, demanded a blood test, at which point Reed agreed and promptly bolted. It wasn't until January 2008, after she made the Secret Service Most Wanted list, that she willingly confessed all the way over in Chicago. Number 8. Fake Doctor. So it's one thing to steal an identity, but it's a whole other level to impersonate the same person and get caught not once, not twice, but 3 separate times. It all started in 1976 for Gerald Barnbaum, when he decided to take the easy route to a cushy doctor job after losing his pharmacist's license. Instead of medical school, he found an actual doctor by the name of Gerald Barnes, legally changed his name, and just straight up asked the California Medical Board to send him copies of his qualifications. With that, he found a job and played doctor, which went fine until 1980, when he missed the patient's untreated diabetes and took the blame for his death 2 days later. After he served his time, he tried the doctor thing again in 1984, under the same name, but he was caught and sentenced to 3 years behind bars. It wasn't until he found another job at a Los Angeles health clinic in 1995 that he was finally in prison for life just 1 year later. You have to wonder why he kept at it, but you can't teach an old dog new tricks, I guess. Number 7. Reliving high school. Crime isn't always malicious. Sometimes it's just about exercising your personal demons, like in the case of Wendy Brown. Honestly, this one is as depressing as it is creepy. The Wisconsin mother didn't exactly have the best childhood. She had an abusive relationship with her mother, which led to a speech impediment and bullying at school. And to make matters worse, she got pregnant and dropped out of high school at age 17, all the while seeing her sister flourish as a cheerleader. So you can kind of see why she might have pined for some good old days of her own. But in 2008, the 33-year-old took matters a little bit too far when she used the birth certificates of her 15-year-old out-of-state daughter to enroll at her local high school. Brown took classes with teens less than half her age, tried out as a cheerleader, and even attended a pool party with her classmates without getting rumbled. But the jig was up after 2 weeks when the teachers reported her truant and found her in police custody over a separate forgery charge. Brown was sentenced to 3 years in a psychiatric institution, but on the bright side for her, she did use that time to finally get her high school diploma. Number 6. Prostitution. It has to be a pain to get a phone call at home asking to make bail for someone, but it's just baffling when that call is to bail out yourself. In 2007, 20-year-old Floridian Brittany Ossenfort got a call from Orange County Sheriff's Office asking for the cash to get none other than Brittany Ossenfort out of the slammer. But in reality, this Brittany was actually Michelle, Ossenfort's transgendered former roommate, known by the state as Richard Leslie Phillips. Michelle contacted Brittany from jail after she was caught offering oral sex to an undercover police officer for $30. And to make matters worse, she used her old friend's name on the police report. As if that wasn't embarrassing enough for the young woman, she had to deal with some very annoying long-term consequences too. For one, her name and information was on the police website for a whole week. But even worse, the police couldn't alter the details of the report on their system, meaning in the eyes of the law, she was arrested for soliciting sexual acts. Now Ossenfort has to carry documents with her at all times to prove she isn't a prostitute, just in case she's ever actually arrested. Number 5. Revenge Exhibition.
Alright, so that gives you an idea of some. I'm not going to go into all of them. Maybe I'll share them for another day. But, yeah, some people will do anything. Moving on. Theft of intellectual property. Intellectual. What's that? Well, you can probably see below by the chart, which is in your book. Intellectual property is a blanket term describing the many varieties of products attributable to human intellect, thus intellectual property. Theft of intellectual property is a crime. Well, for example, illegally downloading songs, who doesn't do that? Or movies, oh my goodness, from the internet, or stealing the secret recipe for Coca-Cola to make your own soda brand. So, a patent, a trademark, a copyright, or a trade secret. Thus, the theft of intellectual property, which in many cases would be a felony. Of course, it could be federal, it could be state, most likely not local, but you get the drift. All right, I saw a video and I wanted to share. It's a short one, and there's a reason that I teach what I do, and I tell you every day how much I appreciate you. So I kind of did this, well, for a reason. This is why I give you your voice in class. This is why we talk about real life in our profession. This is why I give you stories and I tell you how important it is and how lucky you are to be taking classes in a college where you have instructors that have a lot of personal experience and life experience in this profession. This is why you're encouraged to speak your mind in my class. This is why I encourage you to think critically. Your opinion matters. This is why I tell you that I've been in your shoes and that I understand that it's hard to be a student. This is why I use a multifaceted approach to teach my lectures, that we cover the information and we just don't go and read through the book, which is fine, but it's not my way. I want to help those who are visual learners, who are audio learners, that need to read and hear the information. Because I want to keep the class interesting and you motivated. Because to me, your opinions and successes matter. Let's watch this. Yeah, hang on. Imagine that we had classroom lecture halls like this in North Georgia Tech. I know all your names. That's it. Okay? Anyways, if you have any questions, as always, let me know. I'll see you soon.